viewers, I am Dr. Purnima Khanna from Khalsa College of Law, Amritsar. In present module, we will discuss about the legal history of law relating to sexual harassment of women at workplace, which happens to be a very pressing as well as a sensitive issue. The objectives of the present module are, firstly, to elaborate the meaning of sexual harassment, then to highlight the constitutional perspective on the subject matter, and lastly, to analyze the relevant provisions of the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. Dear viewers, let's begin with the prelude. With the onset of industrialization and globalization, there are now more women working in every industry, which has heightened the need for legislative protections against workplace sexual harassment. As a contemporary welfare state and the world's largest democracy, India has a constitutional framework in place to ensure, protect and address gender equality in all facets of Indian society. A conjoint reading of various provisions provided in the preamble, fundamental rights, fundamental duties as well as directive principles and various women-centered legislations highlight that India has continuously made strenuous efforts to ensure gender equality for women and to eradicate all forms of discrimination against the women folk. In the aftermath of Nirbhaya rape case in 2012, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013, also known as POSH Act, was passed in a hurried manner without any debate or discussion in Parliament. The foundation of this legislation can be traced back to Bhavri Devi rape case in 1997, which led to laying down of guidelines addressing the issue of sexual harassment of women at workplace by the Honorable Supreme Court in Vishakha's case. In this case, the Supreme Court recognized the act of sexual harassment as a violation of human rights. Before detailed discussion of the topic, let's understand the meaning of the term sexual harassment. The term sexual harassment is a complex and subjective term, depending on the culture and beliefs of the parties. Therefore, it becomes challenging to explain the term in definite manner. However, various authorities and organizations have given a general meaning to the term. As per United Nations guidelines, sexual harassment is any unwelcome sexual advance, request for sexual favor, verbal or physical conduct or gesture of a sexual nature or any other behavior of a sexual nature that might reasonably be expected or be perceived to cause offense or humiliation to another. When such conduct interferes with work, is made a condition of employment or creates an intimidating, hostile or offensive work environment. While typically involving a pattern of behavior, it can take the form of a single incident. Sexual harassment may occur between persons of the opposite or same sex. Both males and females can be either the victims or the offenders. Sexual harassment, according to International Labour Organization, is a widespread phenomenon that undermines equality at work. It can have a negative impact on victims' pay, career progression and working conditions, and potentially drive individuals out of the world of the work. While it can affect anyone, sexual harassment particularly affects women and reinforces stereotypes about their abilities and aspirations. It also contributes to fewer women entering or remaining in the labour market, adding to the labour force participation gap and to women being paid less than men, aggravating in gender pay gap. Sexual harassment is one particular form of discrimination based on sex. The Honorable Indian Supreme Court in Vishakha versus State of Rajasthan 1997 held that sexual harassment includes such unwelcomed sexually determined behavior, whether directly or by implication, as number 1, physical contact and advances, then a demand or request for sexual favors, or sexual colored remarks, or showing pornography, or any other unwelcomed physical, verbal or non-verbal conduct of sexual nature. In April Export Promotion Council versus A.K. Chopra 1999, it was held that sexual harassment is a form of sex discrimination projected through unwelcomed sexual advances, requests for sexual favors and other verbal or physical conduct with sexual overtones with directly or by implication, particularly when submission to or rejection of such a conduct by the female employee was capable of used for attracting the employment of female employee and unreasonably interfering with her work performance and had the effect of creating an intimidating or hostile working department for her. As far as the constitutional perspective is concerned, since sexual harassment of women at workplace is against the principle of gender equality, it is also a violation of the fundamental rights under Article 14, 15, 19, 1G and 21 of the Constitution. In the historic case of Vishakha versus State of Rajasthan, the 3-judge bench of the Supreme Court categorically held that each incident of sexual harassment at work results in a violation of the fundamental rights of gender equality and the right to life, dignity and liberty under Articles 14, 15 and 21 of the Constitution. It also causes the violation of victims' fundamental rights under Article 19, Clause 1, Subclause G to practice any profession or to carry out any occupation, trade or business, and therefore attracts the remedy under Article 32 for the enforcement of these fundamental rights of women. The court reaffirmed that the fundamental right to carry on any occupation, trade or profession depends on the availability of a safe working environment. The Criminal Law Amendment Act 2013 has inserted a new section 354A in the Indian Penal Code, which deals with the offence of sexual harassment. The definition given in the section is quite similar to the definition given by Supreme Court in Vishakha's case. It provides that a man committing any of the following acts, that is, physical contact and advances involving unwelcome and explicit sexual overtures, or a demand or request for sexual favors, or showing pornography against the will of a woman, or making sexually colored remarks, shall be guilty of the offence of sexual harassment. For the first 3 acts, the punishment provided is rigorous imprisonment for a term which may extend to 3 years, or with fine, or with both. And for the last 2 acts, it is imprisonment of either description for a term which may extend to 1 year, or with fine, or with both. Before passing of the Criminal Law Amendment Act 2013, sections 294, 354 and 509 of Indian Penal Code were used to deal with the cases of sexual harassment. Dear learners, let's discuss main provisions, the relevant provisions of the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. The main provisions of POSH Act are firstly the definition of aggrieved women. Section 2 Clause A defines aggrieved women as a woman of any age who is subjected to any act of sexual harassment by the respondent. Such sexual harassment may have been committed at a workplace. It is immaterial that the aggrieved woman is employed there or not. The definition includes within its purview a victim of sexual harassment at a dwelling place where she is working. Then, who is respondent? Section 2M of the Act provides the definition of respondent as a person against whom a complaint has been made under Section 9 of the Act. To make the definition more effective, any person who abets or aids such acts of sexual harassment shall also be included in the definition of respondent. What is sexual harassment? The definition of sexual harassment is completely similar to the definition given by Supreme Court in Vishakha's case. However, the Act has remarkably enlarged the scope of definition of sexual harassment. It mandates that all circumstances connected to the act of sexual harassment, whereby the respondent makes any implied or explicit promise of preferential treatment in her employment or threatens her of detrimental treatment in her employment or implied or explicit threat about her present or future employment status or interferes with her work, creates an intimidating or offensive work environment for her, or gives her humiliating treatment which may affect her health or safety, will amount to sexual harassment. Now, what is workplace under the POSH Act? The Act gives a very wide definition of workplace, which includes governmental organizations, nursing homes, sports institutions, as well as a dwelling house. It includes unorganized sector as well as any place visited by the aggrieved women in connection with her employment. Then a very important provision is relating to the establishment of Internal Complaints Committee. The Act makes it obligatory for every employer to constitute a committee in every unit of the workplace with more than 10 employees. The Internal Complaints Committee shall consist of a female presiding officer, 2 members from employees and 1 member from non-governmental organizations or associations. It is mandatory that 1/2 of the total members of Internal Complaints Committee shall be women. It further provides that presiding officer of the committee should be a woman employed at a senior level at the workplace from amongst the employees. It is submitted that the presiding officer of the Internal Complaints Committee should not be from the same organization. It is necessary for the effective functioning of the Internal Complaints Committee that the chairperson should be an independent person and free from influence of the concerned organization. If the presiding officer is from the same organization, there can be efforts to suppress the complaint. Further, Section 4 Clause 2, Subclause B and C provides that members should be committed to the cause of women. Similarly, Section 7 Clause C also uses the words committed to the cause of women. The term committed to the cause of women should be clearly and specifically explained. The section should specifically mention the qualifications for the appointment as members of the Internal Complaints Committee or Local Complaints Committee, as the case may be, so that only deserving candidates are appointed as members of these committees. Section 4, Clause 2, Subclause C provides that one of the members of the internal complaints committee should be from non-governmental organizations or associations or other interests committed to the cause of women. It is submitted that the number of members from such non-governmental organizations and associations should be increased to 2. As Section 4, Clause 2, Subclause B provides for appointment of 2 members from the employees of the concerned organization itself, so equal number of members from the same organization and the NGOs would help to conduct an independent inquiry of the complaint. Any member can be removed from the committee in case of conviction for an offence or abuse of his or her position, or in case he or she has been found guilty in any disciplinary proceeding. Then there is provision for establishment of local committees. At district level, a local committee shall be constituted by the district officer, a district magistrate or additional district magistrate, or the collector or the deputy collector may be appointed as the district officer by the appropriate government. The complaints of sexual harassment from establishments where the internal committee has not been constituted due to having less than 10 employees, or where the complaint is against the employer himself, can be filed directly before the local committee. The local committee shall consist of a female chairperson, 1 female member to be nominated from the women working in block, taluka, tehsil, ward or municipality, 2 members from the NGOs or associations. The concerned officer dealing with the social welfare of women and children development in the district shall be an ex officio member. The removal of the members of the local committee can be on the same grounds as in case of removal of members of internal complaints committee. Dear viewers, let's discuss about the provision relating to filing of the complaint of sexual harassment. The Act mentions that an aggrieved woman may take a complaint of sexual harassment at workplace to the internal complaint committee or the local committee, as the case may be in writing. It further provides that where such complaint cannot be made in writing, the presiding officer or any member of the committee or the local committee, as the case may be, shall render all reasonable assistance to the women making the complaint to reduce the same in writing. The limitation period for filing the complaint is 3 months. It is submitted that on the request of a complainant, a counsellor shall also be made available to an aggrieved woman. Conciliation. The Act mandates that at the request of the aggrieved women, the committee or the local committee, as the case may be, before initiating inquiry under this Act, take steps to settle the matter between her and the respondent through conciliation. In case a settlement is arrived at between the parties, the internal complaints committee or the local committee, as the case may be, shall record the settlement so arrived and forward the same to the employer or the district officer to take action as specified in the recommendation. After the conciliation between the parties, no further inquiry shall be conducted by the internal complaints committee or the local committee. Now, how the inquiry into the complaint is conducted? The internal complaint committee or local committee, on receiving the complaint, shall start an inquiry according to service rules applicable to the respondent. In case of absence of such rules, the committee shall forward the complaint to the police within a period of 7 days for registering the case under Section 509 of the Indian Penal Code. for the purpose of conducting the inquiry. The internal committee or the local committee exercises the same powers as are vested in a civil court under the Civil Procedure Code. Thus, the committee may summon witnesses and require the protection of documents before it. The inquiry shall be completed within a period of 90 days. Action during pendency of inquiry. During the pendency of an inquiry, the internal complaint committee or the local committee, on the written request of the aggrieved women, recommend the employer to transfer the aggrieved women or the respondent to any other workplace. Grant leave to the aggrieved women up to a period of 3 months. Such leave shall be in addition to the leave she is otherwise entitled. Inquiry report. The committee has to submit its inquiry report to the employer or district officer within 10 days of its completion. If the committee finds that allegation against the respondent has not been proved, it shall recommend that no action shall be taken against the respondent. In case the allegation against the respondent is proved, the committee shall recommend the employer, firstly, to take action for sexual harassment as a misconduct in accordance with the provisions of service rules applicable to the respondent, to deduct the amount of compensation from the salary of the respondent. As far as punishment for false or malicious complaint is concerned, the Act provides that in case the committee finds that the complaint filed by the complainant is false or malicious, or she has produced any false or forged document in order to support her complaint, it may recommend the employer of the women to take appropriate action against the complainant as per the applicable service rules. As far as compensation is concerned, the Act provides that for the purpose of determining the compensation to be paid to the aggrieved women, the internal complaint committee or the local committee, as the case may be, shall have regard to the income and financial status of the respondent. It is humbly submitted that the determination of the compensation should be based on the gravity of the offence and not on the income and financial status of the respondent. In the case of Ms. G versus Novasoft Technologies, the Madras High Court ordered the company to pay rupees 1.68 crores as compensation to the women employee aggrieved of sexual harassment. The court remarked that if the company had set up a committee to inquire into allegations of sexual harassment, the litigation may have been avoided. As far as the duties of employer are concerned, it is mandated by the Act that it is the duty of every employer to provide a safe working environment at the workplace, which shall include safety from the persons coming into contact at the workplace. Secondly, display at any conspicuous place in the workplace the penal consequences of sexual harassment, and organize workshops and awareness programs at regular intervals for sensitizing the employees with the provision of the Act and orientation program for the members of the internal committee. Provide necessary facilities to the internal committee or the local committee, as the case may be, for dealing with the complaint and conducting an inquiry. The employer shall assist in securing the attendance of respondent and witnesses before the internal committee or the local committee, as the case may be. Make available such information to the internal committee or the local committee, as the case may be, as it may require having regard to the complaint made by the aggrieved women. Provide assistance to the women if she so chooses to file a complaint in relation to the offence under the Indian Penal Code. Cause to initiate action under the Indian Penal Code or any other law for the time being in force against the perpetrator, or if the aggrieved woman so desires, where the perpetrator is not an employee in the workplace at which the incident of sexual harassment took place. Treat sexual harassment as a misconduct under the service rules and initiate action for such misconduct. Monitor the timely submission of reports by the internal committee. Finally, the annual POSH report. It is worthwhile to note that proper monitoring is required for the effective implementation of the POSH Act. One of the concerns is the Act does not satisfactorily address accountability, not specifying who is in charge of ensuring that workplaces comply with the Act and who can be held responsible if the provisions are not followed. The Complaints Committee shall prepare annual report to be prepared January 31st every year to the concerned district welfare officer. It shall consist of following information. It shall mention total number of complaints of sexual harassment filed and disposed of in the year. It shall mention the number of the cases which have been pending for more than 90 days. It shall also disclose the number of workshops or awareness programs conducted for the general public regarding the POSH Act. Dear learners, the foregoing discussion highlights that framers of the Indian Constitution ensured that adequate provisions are enshrined in it to eradicate the historical gender disparities. Indian legislature, through various laws, and judiciary, through its landmark and historical judgments, have time and again retreated and strived for the gender balanced society. The enforcement of POSH Act is path-breaking step in this direction. It can be concluded that the Sexual Harassment at Workplace Prevention, Prohibition and Redressal Act 2013, if implemented effectively, can be a potent tool to create a healthy and safe environment for women at workplace. Dear learners, I hope you find this lecture informative. Thank you very much.